The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. It is Friday. It's time for Ask a Lawyer. Thank you for tuning in to our 20th episode. To me, that's amazing. We'll see how far we go.
I'm going to see when you stop counting.
You know something? Isn't that a mile mark too?
It is.
You do that with everything. You do that
Yes.
when you have a child.
Uh-huh.
First you're starting in weeks and then months, and then at some point you stop.
Yeah, you don't care anymore, right?
And the only thing you can't stop counting is when you're married, your anniversaries, or you get in trouble.
Yes. Yes, because there's a reminder coming your way if you don't if you don't remember.
Anyway, folks, if you have calls, we had a lot of calls last week. It took up almost the entire hour, which is wonderful. If you have calls, give me a call here at 340-1590. I'll try to answer whatever questions you have. And if it's an area that I'm not really familiar with, I will do my best, and I will tell you that. But, I do general civil litigation, so I handle a smattering of a little bit of everything. Now, an example of that. I didn't have this planned. Cliff Desmond advertised the Sailfish beer walk tonight.
Okay.
And, of course, we all know you can't drink and drive, but can you walk and drink?
Yeah.
Are you sure?
Oh, well, see, I think that they have, permission.
Well, let me tell you something. There is a Florida statute. It is illegal for someone to consume alcohol in public.
Okay, yeah, okay.
It is also a crime to be...
That's why they have those little brown paper bags.
Well, yeah. It is also a crime to be intoxicated in a public place to the degree that the person may endanger himself, other people, or property. And you may not drink in a public conveyance like a bus or cause a disturbance. Now, what happens when you do this? It is a crime. You could be arrested.
How many walkers do we have going on there?
Now, I'm not trying to scare you folks. I'm just saying do it the right way. Follow the rules. Follow the guidance that you're given by the hosts, and y'all be okay. I'm just saying, Cliff talks about this wonderful event tonight, and it is a wonderful event, and, I'm not really a beer drinker, but if it was a Diet Coke walk, you'd have me there.
It puts a new twist to the term beer run.
That's right. Okay. If you were to not follow the rules or to deviate from the walk and end up on a street somewhere else and have your bottle of beer and you're drinking it in public and some officer decides he's not happy about that, it's interesting. This statute, they have a choice. They can be nice, and they can drop you off at home.
I always say that the officer is the first judge you meet.
That's true. This discretion starts there. Or you could actually get arrested.
And meet a whole different
judge.
judge.
And it's a second-degree misdemeanor in Florida. The penalties include a fine up to $250 and up to 90 days in jail, or both.
Wow.
They always have that or both at the end of a statute. Gives the judge discretion.
Okay.
So, it's interesting. We always talk about don't drink and drive. There are other obligations, too.
And it's don't drink and drive anything. I mean, you're not supposed to drive a boat. And if you hop on your riding lawnmower, you're still driving.
And there are different, you're right, and there are different statutes that deal with those things.
I mean, it is sort of a motor vehicle.
You're right. Now, if you're riding a motorized bicycle, that is a motorized vehicle, too. That was tested in the courts a long, long time ago.
What if you're pedaling?
If you're pedaling, you are not violating that particular statute of driving while intoxicated. However...
It goes back to the walking then.
Yes. You may be intoxicated in public to a degree that it's unsafe. If you're riding your bicycle on a road that's traveling with heavy cars, it's unsafe to you or them, you could get arrested for that.
Okay.
And it wasn't really the topic, but this is what lawyers have to adjust. And I just heard Cliff talking about that, and I thought I would mention a little bit something about the Sailfish Beer Walk tonight. If you're heading out there tonight, go, enjoy yourself, have a few beers, get a little bit happy. But just remember, there are rules even to walking. And it's not just right foot, left foot, right foot, left foot. All right, so what are we going to do today? I've been, it's like I was teasing sexual harassment for so long, and it took a while to get there.
Right.
I've been teasing landlord and tenant, and, I plan to get there too.
Oh, goody.
And we could do that today. But I thought, a couple people have asked me, why aren't you telling any war stories? And a couple people have said, whoever's listening might find some of this stuff interesting. So I thought I would tell a war story that makes me look very foolish, and those are the best kind. And it is actually from my very first trial out of law school. So I must have been 25.
How'd that work out for you?
That is an eon ago. Well, you see, this is what happens when you're practicing law in a large law firm, and you're a first-year associate. If they're going to allow you into a courtroom at all, it is going to be to cut your teeth on a case to lose.
Okay.
It's not going to be a winning
case.
And so I got called one day into a partner's office who said to me, we're handling a case pro bono, which means for free. We're doing it because of a very important client who asked us to help a friend. So the partner was doing a favor for a client that he wanted to keep. And he says to me, here's the file. Go work it up. Trial's in like 3 weeks or something. And I looked at him. Fortunately, I tried a couple cases in law school under the supervision of an attorney. But still, this was the first real case. And you never want to lose. He told me it was a losing case. Don't worry about it. Just do the best you can. Don't embarrass the client or the client's wealthy friend.
Right.
So I go back to my tiny little cubicle. In those large law firms, you work in tiny little cubicles. And I look at the case, and it is a case for breach of an automobile lease. Non-payment. Okay, seems pretty straightforward. I look through the file. They have my client signed lease agreement. They have his signed personal guarantee. It is clear that payments stopped being made. He still has the vehicle. Yeah, this looks like a losing case. And so now what is an attorney's job there? It's not to run for the high hills, although I thought of it. Job is to look at it and say, what can I do with this? How can I make lemonade out of lemons or any of those other fancy allegories or whatever they're called? And I couldn't figure it out. But one of the things they really trained me in my particular law school was on the rules of evidence. So I started looking at, how are they going to introduce the lease and the guarantee? And they're not very hard, really. And I had a plan. I didn't think it was going to work. And we went to trial. And fortunately for me, my adversary representing the car dealership was also doing her first trial.
Wow.
So you had two people who didn't know what they were really doing trying a case before a very experienced judge who was, fortunately for us, a wonderful judge with a good sense of humor and a willingness to try to help teach. You got to
start somewhere.
You don't
right?
always get that, especially if you're thrown into federal court. This was state court in New Jersey. For anybody who knows it, in Middlesex, Monmouth County. And, all right, so they go first, obviously. They're the plaintiff. They're suing us. And she calls the client from the car dealership to the stand. Okay. And she goes to introduce the lease into evidence. Objection, Your Honor. Judge looks at me. What's your objection? I said, well, we haven't established the authenticity of the lease. We haven't established this is truly the lease. Hadn't heard that one before because usually that's not something that's argued.
Right.
Usually it's something agreed upon before trial.
Mm-hmm.
So he says to me, Mr. Address, would you like to voir dire the witness? Now, I had heard about voir diring a jury. I had never heard about voir diring a witness. So I was a little confused.
Mm-hmm.
We had a jury, by the way. And I sort of figured out very quickly he meant, I want to question the witness before she continues her examination, which is a little out of order. So I go up and I go, Mr. Whoever you are you familiar with my client at all? No. Have you ever met him? No. Have you ever seen any document with his signature? No. How can you testify that this is his signature on this document? Well, I can't. Your Honor, I move to, exclude this lease into evidence. He asked the other attorney if she can somehow fix it, which is very easy, frankly. She didn't know how to do it.
Okay.
The lease was excluded from evidence.
Okay.
And in my mind, I'm going, oh my goodness! And I do something I had seen on TV. Your Honor, I move for a directed verdict. And he says to me with a smile, not now, Mr. Address. And I'm thinking, why not? I mean, the lease isn't in evidence. It can't prove their case. Why can't I just
what
get
else
this
do
thing
they
over
have
with right
other
now?
than the lease, too?
And
yeah.
by the way, for you out there, the rule is you can't move for a directed verdict until the other side has finished their case. And the reason for that is, what else might they have? But I didn't know that my first trial.
Okay.
They didn't teach me that part in law school.
It was worth a try anyway.
It was worth a try. So they then try to introduce the guarantee. And I think to myself, oh, if the guarantee gets in, then who cares about the lease? Objection, Your Honor. Lack of authentication. He knew where I was going. Would you like to voir dire the witness? Hey, I now knew what voir dire the witness meant. Pause for laughter. Any studio canned laughter we have here? No? Okay. So I go up, and again, I go through this routine. How are you able to authenticate this is his signature? Mm-hmm. Well, I can't. Your Honor, I move to exclude the guarantee from evidence. Granted. Walk back to the table. I think to myself, okay.
What else could they have?
No, I'm not thinking that. You're thinking that.
I'm thinking what
That's
else?
a smart thing to think.
Yeah.
I'm not thinking that. I'm thinking they didn't get the lease in. They didn't get the guarantee in. Those are the only two documents that tie my client to this whole agreement. Your Honor, I move for a directed verdict. Well, now the judge says to me, Mr. Address, you just can't do that yet. He says it nicely. Mm-hmm. He's clearly trying to send me a message. I'm not getting that message. By this time, the jury is chuckling. The jury has figured out what the problem is, but I'm too in the heat of it. Mm-hmm. I haven't figured it out yet. So then the other attorney tries to get her client to testify to a phone conversation that her client had with mine, where my client acknowledged signing the agreement and signing the guarantee. And I go, oh, no lease, no guarantee, but an admission of a party, that's good enough to establish the contract. So she goes to try to question him about the objection, Your Honor. Lack of authentication. All right, Mr. Address, go voir dire the witness. So I go up there, and I said, you had told me earlier you had never met my client, right? That's right. Mm. You had never previously spoken to him on the phone. Is that right? That's right. Did you call him at his office and, ask for him, David Palmer? I remember that. Or did he call you? Somebody called me. So you have no idea who you were really speaking to, do you? Some stranger calls you, says he's David Palmer. How do you know it's David Palmer? Did you call him back at his office and ask the receptionist, may I speak to David Palmer? He answers, and now it's the same voice. Mm-hmm. No. So you really don't know who you spoke to, do you? No. Your Honor, I move to suppress any testimony regarding this telephone conversation. Granted. No lease, no guarantee, no telephone conversation. But I'm getting smarter. I don't ask the judge for a directed verdict.
Okay.
Plaintiff rests. They haven't proven a darn thing.
Mm-hmm.
Now, I am so excited to question my first witness officially as a lawyer, my client. Your Honor, I call David Palmer to the
Now, would
stand.
you have had to call him, or should you just have let it be?
Well, in a civil case, we'll get to that in a second. Okay. I call David Palmer. The judge looks at me and says, Mr. Address, isn't there something you want to ask me? I don't know what the heck he's talking about. I want to call my client, and I've had my examination prepared. Mr. Address, I think there's something you want to ask me. Now, the jury is chuckling loudly. I think my adversary might have been chuckling lightly. I think even my client understood what was going on. Perhaps the court reporter, the deputy, they all figured it out.
I think I get it right now, too, and I wasn't there.
I didn't. I was in the throes of wanting to question my client. And so for a third time, most judges would have let it go, and now I'm going to screw up. I'm going to screw up winning this case. So I'm going to put my client on the stand. I'm going to subject him to cross-examination. He's going to screw it up, and I'm going to lose. Had a nice judge, understood both attorneys were inexperienced. Judge says to me for a third time, Mr. Address, there is a question you have been asking me all morning long. Now's the time to ask it. Ask me the question. Well, okay, you don't have to hit me over the head by a 2x4. Well, maybe you do, but let me tell you, if this wasn't a 2x4, it was a 4x8. So I realized, Your Honor, I move for a directed verdict. He has to tease me. It's like having a fish on the reel. He had to tease me. Mr. Address, what are the grounds? Oh, I got to give grounds? Well, it's now lunchtime. He says, Mr. Address, let's do this. Let's take a break for lunch. We'll reconvene in an hour, and let me hear your grounds for a motion for directed verdict. All right, so now I had time to prepare my motion for a directed verdict. So what do? I know he's going to, I should have known he's going to grant it. I mean, he was begging me to ask him the question.
Right.
But again, it's your first trial, and, I sit down at the lunch table. My client has lunch. I push everything away. I have a legal pad in front of me. And I'm thinking, okay, what are all the grounds? And I think I come up with 18 grounds, 18 reasons that a directed verdict should be granted. I could have done it in 10 seconds. Your Honor, they couldn't get the contract in. They didn't get the guarantee. There's no telephone conversation. They have no evidence this was my client. Motion for directed verdict. Boom, done. I wasn't experienced enough at that point. I hope people aren't calling in because they're sitting by their seats and they're listening to the story and they don't want to interrupt it. If you are, just at least get on the phone lines in order. Anyway, so I go back after lunch. Your Honor, move for directed verdict for the following 18 reasons. And I could see the judge's eyes roll. And the jury's no longer there because this is not a part of jury hears. And I don't spend an hour on it, but 15 minutes. I give him 18 reasons why the motion for directed verdict should be granted. He listens to the other attorney, who really is not able to rebut anything. I should have understood at that point I'm going to win, but I didn't. I'm wondering whether now I'm going to have to put my client on after all. So what the judge could have done, and if he was busy he would have done, is just said, motion granted, case dismissed. He toyed with me. He toyed with me like I was on a fishing line. He said, well, as to reason number 1, which is, I find, and he finds in our favor. As to reason number 2, and he starts going down it in order. And
at that point you were thinking, why did I make 18 reasons?
No, I'm thinking, okay, we're winning each one so far.
Okay.
And don't ask me why, but reason number 14, I think it was. Could have been 15. Who knows, 13. My memory is 14. Reason number 14 was the key one. I don't know why I didn't make that number 18 or number 1, but it was number 14. So when he finds in our favor on 14, I lean over to my client and I whisper, "That was the important one." So now I'm just sitting there. Now I'm rating for 15, 16, 17, and 18. Mm-hmm. Finally, he says, motion for directed verdict granted, case dismissed. Wow. I won. My client was absolutely over the moon. Mm-hmm. Never should have won this case. Couldn't believe he did. The other client is yelling and screaming at the female attorney. We leave the courthouse, and now I have a 2-hour drive back to my office. Folks, in New Jersey, you can literally go from the top of New Jersey to the bottom of New Jersey in no more than 3 hours. So I have a 2-hour drive back to North Jersey to my office. And I'm trying to plan, what am I going to say to this partner? No cell phones, folks.
Right.
And I wasn't going to go to a payphone and call him. So I'm driving back, and I go to his office, and I walk in. And he said, "Trial's over?" I said, "Yeah." "Now I'm going to milk it." Mm-hmm, mm-hmm. He says, "What happened?" I said, "Wow, what an experience. I learned that you can't ask for a directed verdict until the other side's done with their case." He said, "Oh, wow, yeah, that's, of course, everybody knows that."
Wondering how that even came up, probably.
I said, "Well, we won." And the eyes bulge a little bit. The mouth crinkles. And then I drop the bomb. By a directed verdict at the close of plaintiff's case, we never even had to put on a case. And the mouth now is wide aghast. The hands are outstretched in shock. "What happened?" I told him the story that I just told all of you. Guess what? I was a first-year litigator. I started getting more trials. And the other first-year lawyers hated me. Oh. Because they're still doing research and all that kind of stuff, and now I'm in court. So that's the moral of a war story where I did not understand when to move for a directed verdict. I could tell you other stories where I didn't know which side of the courtroom to sit on. They do teach that stuff now in law. They really do. Back then, they did not teach the practical niceties of, how do you really litigate a case? They taught you how to be a litigator, but not where do you sit, when
there's etiquette involved.
Yeah. Very briefly, I once went into, it may have been my first, my second year, who knows. I was always trying to figure out now, okay, I got to be on the right side of the courtroom. Courtrooms are organized differently. I didn't realize for a while that if you're the plaintiff and there's a jury box, you're on the side with the jury box. If the jury box on the other side, you're on the other side.
Okay.
If you're a defendant, you're on the side furthest from the jury box.
Okay.
So, I learned that at some point. But I go into federal court one day for a hearing, and the other attorney has already sat down at the table. So I sit down at the other table. It's my motion. Federal judge comes out. They're God, of course. You all know they're appointed for life. They're confirmed for life. Other than being impeached or dying or retiring, they're there and they're gods in their courtroom. So the federal judge comes out, and this is at a point in time where I'm still scared of federal judges.
Okay, so it's everybody, right?
Well, not when you've been doing it for 33 years. Now sometimes you even argue with a federal judge, but not back then. So the judge says, "Okay, we're here on motion such and such, such and such," turns to the other attorney and says, "You may proceed." And I said, "Judge, it's my motion." He looks at me and says, "Well, why aren't you over there?"
Yeah, you're at the wrong table.
And it wasn't a very good explanation when I said, "Well, Your Honor, he was sitting there when I walked in." That's like saying, "Well, it's his problem." I said, "Well, you should have known better. That's your table." Okay, sorry, Judge.
So when you came in, you were supposed to make them move.
I was supposed to say to the gentleman, as I have in other cases since then, "Would you please go to the next table? That's your table." And I have had to, on occasion, gently suggest to somebody, you're at the wrong table. I was not about to have that happen to me again. So we have war stories we tell. Hopefully that was a little amusing to somebody. Let's move into landlord-tenant.
Yay!
Residential landlord-tenant. It is not a complicated topic, but it is by no means simple either.
Now, I have a question right out of the box.
You have a question?
A question.
A question.
Is it different state by state?
Oh, yes,
for
absolutely.
landlord-tenant. Okay.
Absolutely.
Okay.
You know, that's the great thing about our democracy. All rights that are not enumerated in the Constitution are reserved for the states. There is nothing in our Constitution about landlord-tenant law. So that is not a federal issue unless it's a federal property.
Okay.
But no, most states have different laws about almost everything. I mean, one state, is 0.08 for intoxication. Another could be 0.10, 0.06. When can children drive a car? I think there are some southern states
when they
where
can buy them,
at 10, you can drive it on your own farm.
Yeah, that's true.
So, I mean,
That's
states
true.
are wildly different.
Yeah.
And, sometimes people get upset about, well, why is this legal in one state and not legal in another? But if it's the type of issue that is not a federal issue, then if you really want it to be one way, go move to that state.
Right.
Why does one state have no income tax? Florida. And another state, New York, you have to pay state income tax
Jeez,
and
yeah.
local income tax.
Right.
My goodness. You don't like it? Move to New Jersey where you pay state income tax. You really don't like it? Move to Florida. Or a few other states now that
there's a
don't
few.
have state income tax. So, landlord-tenant is very different, in other states. I mean, maybe the skeleton is the same, but details do change. Landlord-tenant, let's start out with, is called a summary proceeding under Florida statutes. And what that means is it's designed to be over with quickly. It's not a case that takes 2 years to get to trial. It's a case that probably won't even take 2 months. It goes to the head of the line. And that's why we even have county judges that handle landlord-tenant court, because this way we go through tons of them at a time. So what happens? I mean, there's so many things that could happen. You go rent, a house, an apartment, a trailer, whatever it is, a condo, whatever.
Should you have a written agreement?
Oh, you really should, folks. My goodness.
Are there people renting without?
Oh, yeah. And there's a statute that says what happens when you're doing that, too. But, what really happens is the details of the agreement. Well, he promised that he would pay for the heat. Where's the proof? It's always good to have a written agreement. Folks, it is good to have a written agreement on almost everything. There was a time where if you really knew a person, handshake, that was their bond. Some people try to say it now, and I say to my client, get a written agreement. Maybe there are a few people out there, too, that will live up to their word. But honestly, I'm sorry, most don't. You're always better off with a written agreement no matter what it is. Unless it's, $1 for tiddlywinks. I remember that game.
Yes,
being a
I
kid.
do too.
So, all right. The lease determines how long the landlord has to give you before he tries to kick you out. Let's say you don't pay your rent. There are other rules if it's for some other alleged thing that you did wrong. And it depends upon the lease. So if there is no lease, if it's a verbal agreement, the rules are even more different. And the statutes spell it out. So one of the things you want to look at is, what does the lease say in terms of not how long it is, but what is the frequency of payment of rent? That's the key. Okay?
And it usually should say due on or before a specific date.
Well, that's
of
for
that
the
month.
rent payment due, but then what happens if you miss a payment? How much time do you get, notice of eviction before he files an eviction action?
So a grace period.
Grace period, yeah. And the grace period that's in the lease saying, you have 5 days before I start charging, that's not the grace period. It's once the landlord puts a notice on your door or serves you with something, that's the legal notice.
Okay.
Okay. So let's tell you this also. The general landlord-tenant statute for residential, attorney's fees go to the prevailing party. So if the landlord is harassing you or trying to get you out for some baloney reason and you prevail, there's a good chance you're going to get a part of your attorney's fees at least back as a judgment by the court against that landlord. Now, if the landlord wins, you may have to pay his attorney's fees, which is an incentive if you know that you're wrong, if you know that you didn't pay the rent, if you know that you're not allowed to have a pet and you have 5. Don't fight the thing. Either get out, or if you can't get out in the 3 days or 7 days that you're given, then okay, come to a lawyer. And I've negotiated termination agreements all the time. If you negotiate it, you're okay. But if you just sit there and make him file an eviction action, you may get hit with attorney's fees.
And usually I would think that by then the lawyer's just happy you're gone.
The landlord, you mean?
Yes.
There are those that are vindictive. Security deposits. That's a big issue we always get a call on.
Yeah, because landlords do not want to give them back.
That's right. And the statutes are very clear on this. When you first provide a security deposit, the following rules apply. Within 30 days, the landlord must make certain disclosures to you. The landlord has to tell you the name and the address of where your money has been deposited. Has to tell you whether the account is receiving interest. And has to contain a specific disclosure of rights that's in the statute. The failure of the landlord to give you that notice, and it happens a lot, is not a defense to an eviction action for your failure to pay rent.
Mm-hmm.
However, it is a defense when the landlord attempts to take any part of your security deposit. By failing to give that notice, the landlord has forfeited any right to keep your security deposit. So that's one of the things we look at when a prospective client calls and is upset they haven't been given their security deposit back. Not only do we ask, because there's another notice you have to be given after you left, you have to be given a notice that conforms to a statute that says if the tenant landlord is going to keep any part of that security deposit, they have to give you notice, they have to tell you what part is being kept and why. They don't do that, they forfeit the right to keep the security deposit. So there are 2 ways a landlord could lose that right to the security deposit. Up front, by not giving you the proper notice, and in the end, by not giving you the proper notice. And so, people often are willing to walk away from the security deposit, and I say, well, why?
Because they skipped out in the middle of the night.
Well, no, you may need it, for the next place.
Mm-hmm.
Now, does it make sense if the security deposit is the only issue? Does it make sense to come hire me to fight for your security deposit? No. Now, are there other attorneys who do nothing but landlord-tenant or nothing but small claims? Yeah, there are. And they, on a day where there's a landlord-tenant call in the court, they may be there representing 20 clients. Those attorneys you may be able to retain cost-effectively to try to argue on your behalf. But the reality is, whether it's landlord-tenant court or whether it's small claims court, virtually anybody is capable of going in there and representing themselves. It's the way it's designed. Is it a good idea to get some professional advice? What to say to the judge, how to say it, what documents maybe to show the judge. These are not complicated things. They take 15 minutes.
Well, if you have documents, that should be half the case,
right? But a lot of people may not know. Landlord's supposed to give me a notice within 30 days after I moved in. Okay, well, an attorney can tell you that.
See, but that should just be part of the lease then.
It should be, but
make
sometimes
it easy.
it
Put it
isn't.
in the lease.
Well,
But now, if it's a verbal situation where you've got, a house, say you own a house,
yes,
and you're going to rent the house to this nice family, and you say it's, $800 a month, and it's due on the 1st, I'll be here by the 5th if I don't have my check, enjoy the house.
That's right, and that's great for the rent now, but if he hasn't given you the notice about the security deposit,
right.
he's not going to be able to keep a security deposit.
Okay.
So when you want your security deposit back, you've moved out. Let's assume you've moved out under normal circumstances.
Mm-hmm. So you've done everything right.
Right, and you assume you're getting your entire security deposit back.
Mm-hmm. The place is clean. There's no holes in the walls, and you didn't leave owing last month's rent.
That's right. That's right, which you're also not allowed to use security deposit for that unless the landlord says it's okay.
Right.
And then get a note in writing,
See,
send an email.
And then on the landlord side of that is if you allow that tenant to use their last, you're going to have a really nasty house.
No, that is not true. No. If the landlord comes in,
yeah, it's true.
The last month and takes a look at the place and sees you've been there a year, 2 years, 5 years, and the place is in great condition, and you've been a good tenant, and says, okay, you can use your security deposit for the last month's rent. I have a funny feeling that when you leave,
you'll get burned every time.
I disagree. I think that
I'm
a lawyer and I'm cynical, but I don't agree.
I ran an apartment complex in West Texas with 104 units.
Were they low-income rent type of
places?
No. Or
no.
nice places?
This was about 5 miles outside an Air Force base. Just regular folk lived there. It wasn't, there was...
So you're saying the military are deadbeats. Is that what you're saying?
Well, it wasn't all military. It's a college town, too.
I'm trying to trap you here.
College town, too. So, yeah. Wow, I can tell you stories.
You're saying college students are deadbeats.
I've had to lock people out of their apartments for non-payment of rent.
You can't. Well, maybe in Texas.
In Texas,
you could do that.
Back then,
this was. In Texas, I think you can kill them, right?
This was a while ago. Yeah, we had this little thing you could put over the doorknob that it was like, how they boot cars in the city? Yeah, you could boot their house so they couldn't get in.
Let me tell you, folks, don't listen to her here. In Florida, that kind of self-help is illegal. Absolutely illegal. The landlord cannot engage in self-help. That is why there is a landlord-tenant court.
No. The sheriff's department came out with the paperwork. You went to the door with the sheriff's department.
So there was a procedure in
Texas.
Definitely.
There was a procedure for that.
Not in Florida, folks.
But this was a long time ago.
Just want to make sure everybody out there understands. Can't do that in Florida. You just can't do it. It's a very bad George Bush impersonation. All right? So the landlord has to mail you a notice within 30 days after you vacate of any intention to oppose a claim on any part of the security deposit.
Or should you get that check within 30 days?
Well,
or the letter that you're not getting it.
You should get that both within 30 days.
Okay.
If he's only claiming a part of it, you should get the other part back.
Okay.
Now, let's say you get that letter that says, I'm keeping all of your security deposit because the house wasn't clean, I had to repair holes in the wall, and you're saying to yourself, and let's say it's true, what is he, nuts? I had merry maids come in the day I left and clean the whole place. Well, maybe it's not a nice landlord.
Mm-hmm.
If you do not respond and dispute that notice within 15 days, landlord gets to keep that security deposit.
Okay. Should you have pictures?
Always a great idea.
Okay.
When you move in, take pictures. My goodness, if it's a nice place and you get renter's insurance, that's helpful too in case there's a problem. Take pictures, and on the day you move out, and everything is broom clean condition, and before you lock that door for the last time and turn in the keys, you photograph the heck out of that place.
Yep.
And these days we use digital cameras. Doesn't cost you a penny. Back in the old days, you use rolls of film. It might have cost you a little bit. But now, there's no excuse for anybody not to completely document almost every part of the house.
Yeah.
Because, man, you could take panoramic pictures now.
Yeah.
So it's easy. Yes, it's a good idea.
And I like that. I mean, there are people who leave it better than the way they found it. Those are the great tenants.
Hey, those are
great tenants.
There are tenants that make improvements, and we'll get to that in another day. But when you make improvements, depending upon the type of improvement you make, You either can take it with you, or it becomes part of what is called the leasehold. Goes back to common law England, 15, 16, 1700s. You make improvements on the landlord's land, it's the landlord's improvements. Not all of them, if it's easily removed.
But you should really get permission before you make those kinds of
Look
improvements.
at the lease. Well, yeah, look at the lease.
Yeah, I mean, even if you paint, you should get permission.
It's a good idea, but the lease may actually answer that question from the start. I mean, that's why I always say, let me see the lease first. And let's see what the lease says and what the lease doesn't say. Because, as we will now get into, even if the lease is silent on certain things, there are certain statutory responsibilities of the landlord and of the tenant. Now, they can be waived in a written agreement to some extent, and it would probably take a week to go into all the exceptions. But for the most part, for example, Florida statute says it's the landlord's responsibility to maintain the premises in terms of complying with the requirements of all applicable building, housing, and health codes. So you have vermin.
The water needs to run in the kitchen.
Yeah, you have vermin, and they've come out and issued a violation. That's the landlord's responsibility. Now, gee, what happens if the lease says it's the tenant's responsibility for pest control? Well, that's going to be the tenant's responsibility for pest control. So, you look at the statute, you look at what may have been changed. Certain things can't be changed. It's also the landlord's obligation to maintain the roof, the windows, the doors, the floors, the steps, the porches, the exterior walls, the foundations, and all other structural components and make sure they are capable of resisting normal forces and loads, and to maintain the plumbing in reasonable working condition. Also, at the beginning of your tenancy, it is the landlord's obligation to make sure that screens are installed in a reasonable condition, window screens. And thereafter, the landlord must repair damage to the screens once annually. How many people didn't know that?
Wow.
Yeah. And
screens.
Unless, of course, you're going to find another part of the statute. If you intentionally are damaging them, all right.
Yeah, like the puppy that you just brought and you weren't supposed to have
but
jump through
the screen. If it's wear and tear, if there was tropical storm winds and a screen broke, landlord's responsibility pursuant to statute. Okay. Now, there are exceptions if the unit is a single-family home, and then there's different rules when it's not part of a single-family home. So, starting with not part of a single-family home, which is what most of them are, usually apartments or condos, unless it's otherwise agreed in writing, that means something in the lease. In addition to the requirements we've already discussed, the landlord shall at all times be responsible for the extermination of rats, mice, roaches, ants, wood-destroying organisms, and bedbugs. When it is necessary for the tenant to vacate the premises because of such extermination, the landlord is not liable for damages, but shall reduce the rent proportionately. The tenant must then temporarily vacate the premises for a period of time not to exceed 4 days on 7 days' notice from the landlord to do the extermination.
So this would be like a big tenting kind of thing where
something like that, or maybe something lesser.
Can't be in there at all.
Now, what is the landlord also responsible for, not in a single-family home, unless it's contrary to in the lease? Locks and keys, the clean and safe condition of any common areas, garbage removal and outside receptacles, functioning facilities for heat during the winter, running water, and hot water. Guess what he's not responsible for? I say he, but guess what the landlord's not responsible for in Florida?
Air conditioning.
That's right. You win the prize. The landlord has to provide you folks with heat,
Yes.
but not air conditioning. Go figure. Thank you, Florida legislature. You probably copied some other state statute and didn't think we're in the South.
Right. Because you could freeze to death up in certain places with no heat.
Right.
And you always hear about the tenant complaints up north about the heat. There's no heat.
Oh, yeah, absolutely.
You know, you walk around your apartment with your jacket on. So...
Your jacket, your
but
fur
nobody,
coat.
I guess you can live without air conditioning, but now without heat. I don't know. I don't.
And that may be the perspective.
Yeah.
But to me, I can't live without air conditioning.
Yeah.
On the situations where we've had tropical storms or hurricanes and power has gone out, I've tried, literally, I have personally tried to find a hotel because I can't survive without air conditioning. I'm a big guy. I can't survive without air conditioning for more than a day.
Yeah.
I will literally go insane. I might go on a killing spree. Get me into air conditioning and I'll be okay. Now I have a pool. I can jump in the pool and maybe sleep in the pool on my raft.
By September, though, when we have our storms here, the water's really hot in the pool. It's not very refreshing. It's just
I like
warm.
that. All right. The landlord, if the unit is a single-family home, the landlord is responsible for working smoke detectors unless it's contrary in the lease. So unless it makes the tenant responsible for it.
Okay.
Now, I would go into the tenant responsibilities, but we are going to run out of time. And tenants, you have some real responsibilities too. I'll tell you the first couple that are the biggies. You've got to comply with all obligations imposed upon you by building, housing, and health codes. That could be as serious as don't create a meth lab. At least I'm getting chuckles in the room here. Or as minimal as don't fail to clean up after yourselves to such an extent that there's feces all around. I mean, maybe that's not minimal, but you hear this stuff sometimes when DCF goes into houses, and
and sometimes there are pets
basically keep
involved.
the house clean. Okay, clean and sanitary is what the statute says. You have to make sure that garbage is removed from your unit in a timely fashion. You have to keep the plumbing fixtures that are in the unit clean, sanitary, and in good repair. Now, if they break, under normal use,
it's a
look at the
mechanical
lease. Right,
thing, and
but
stuff
you
goes
can't
wrong.
be doing stuff like sometimes we learn the hard way. My son learned this the hard way when we were in my house that I currently live in, and he was caught, and my girlfriend started screaming at him. You do not pour hot oil down the garbage disposal.
Right. Or fish tank gravel.
Yeah, so I mean, all right. If we were renting and we had damaged the disposal, we did have to call out a plumber. If we had damaged the plumbing, that would have been our problem. So not the landlord's problem. And you have to use everything in a reasonable manner. I mean, electrical, plumbing, heating, ventilating, air conditioning, everything, needs to be used in a reasonable manner. And you're not supposed to destroy, deface, damage, impair, or remove any part of the premises or property therein belonging to the landlord, nor permit any person to do so. That's the way lawyers write rules. Okay?
Like move out and take the refrigerator.
We can't just say don't damage. We got to say don't destroy, deface, damage, impair, or remove. And you want to know something? They miss things. They always miss things. When I do a document request, it's please produce any documents that relate to, support, apprise, or in connection with. I mean, I try to cover the gambit. And inevitably, I'll get a response at some point that says none. And later on in the case, I'll learn there's something. And I'll challenge it. You didn't ask for that. And you want to know something? That's a good lawyer. You have every right to be hyper-technical. when you're responding to something, and it's duty of the other lawyer to ask the right questions. And doesn't upset me. Okay, it does peeve me at the moment, but not after a little while, because that lawyer was doing a good job. All right.
And you'll remember that one.
I will absolutely. Every lawyer, no matter how good we are at whatever it is we do, some of us are really great with the rules of court, the rules of evidence, substantive rules, and whether it's landlord-tenant or discrimination. You never know it all. You just don't. You practice 30 years. I don't care if you practice 50 years.
There's a certain amount of language manipulation, too.
Yeah.
So, you got to be good at that, too.
So, that's why when I take a deposition, usually it takes a long, long time, because I want to make sure that nobody's trying to wiggle out of anything. But, folks, we are running out of time. All right. And so I've been told, as they say, and I guess I'm learning all the lingo here, to stretch.
Yeah, a little bit.
Because we have 3 minutes. Next week, like last week, maybe we'll take up the whole day with calls wall to wall. Maybe everybody's a little tired this morning. Maybe they found my story about my first trial fascinating. Maybe they really wanted to hear about landlord-tenant. Or maybe
they're sleeping.
Nobody's listening. Mom, are you there? Cheryl, you there? Save me. Call me. Anyway, I'm here to give you folks, different types of information that I think might be helpful to the average person. Not going into, patent law that nobody's really going to care about. And to answer your questions, and I'm happy to, some weeks we do a little bit of a monologue, and maybe you're listening, maybe it strikes something up in your mind that you want to ask later on, and that's okay with me. And other weeks, like last week, and I think the week before that, it's virtually wall-to-wall calls, which, I'll be honest, I find more fun because I don't know what you're going to ask. And that's part of the fun.
Now I've got a question back to the landlord-tenant.
Okay.
Last
question.
If you have a home that you're thinking about renting out,
all right,
should you go to a lawyer to help put the lease together?
Oh, my goodness. There are so many form leases available by reputable companies, by real estate companies. I mean, look at any of the big realtors in our area. If you Google and you find a sample residential lease for a landlord from Coldwell Banker, you can be pretty sure that it's going to satisfy most of your needs. If you have a peculiar concern, give a lawyer a call. Have a consult. Let the lawyer tell you, okay, you should add this provision and this provision. But you don't need a lawyer most of the times to draft a lease for you. All right, so next week, we will discuss landlord-tenant law unless something happens in the world that, changes the itinerary.
Next week, I want you to go over the whole pet thing.
The whole pet thing.
Yeah.
Okay.
Yeah.
All right, pets. And anyway, if you need to, give us a call at our office, 781-8003. And if my email address is Stuart@stuartaddresslaw.com. If you want my paralegal, it's Cheryl with a C, Cheryl. Did I spell that right? At stuartaddresslaw.com. And until next week, then, have a wonderful weekend. And ask a lawyer next Friday at 10:05.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
CBS News on the Hour.